Justice and Associate Justices of the Supreme Court of North Carolina. Yes, oh yes, oh yes. The Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and its honorable court.
Good morning. Our first case today is Lassiter versus Robeson County Sheriff's Department et al. And we will hear from the appellant.
May it please the court, my name is Dwayne Jones with Hedrick Gardner and Kenchel and Garofalo in Charlotte, and I represent the defendant Truesdale Corporation in this matter. I'd like to reserve 7 minutes for rebuttal time. We're here today to figure out what joint employment means as under the North Carolina Workers' Compensation Act. I do think it's important at the outset to note that the full commission in their findings of fact 27 through 31 weighed the evidence. They found that the Sheriff's Department controlled the work of the plaintiff, and they also found that there was no contract between plaintiff and Truesdale, my client. Normally those findings of fact would, since they are all supported by the competent evidence in this case, and also I would argue the preponderance of the evidence in this case, normally those would be binding upon appeal to our appellate courts. But because of a strange quirk in our jurisprudence, jurisdictional facts are reviewed de novo. And in fact, it's the right and the duty of the appellate courts to review the entire record and make their own findings of fact concerning the jurisdiction.
I don't want to get you too off from the merits of your argument, but can I ask you, that is unique to workers' compensation too, right? It's not just outside the norm generally, but we don't, so for example, in a personal jurisdiction dispute or something, we don't find facts.
To my knowledge, it's unique to workers' comp, but I really primarily do workers' comp, so I don't see much of anything else. But yes, it certainly has arisen in workers' compensation cases.
And can you think of a reason why in workers' compensation we would have a rule different than every other jurisdictional fact that is found by fact-finding tribunals?
I can't state anything with certainty. There's something in my head of reading a case, but maybe I'm making it up. But my opinion, at least, is that other agencies are this way too. But the Industrial Commission is a creature of statute. It only has the jurisdiction that the legislature has given it through Chapter 97. So I'm assuming that you don't give an entity jurisdiction and then allow them to define what that jurisdiction is. So maybe they want a little bit more oversight over it. I do think, though, that it can be problematic. Chief Justice Newby, I cited the Cunningham case as to state the law of the standard of review, and I know you dissented in that case. So it can be problematic. I don't think that this case is quite as extreme as the Cunningham case. But I do think that, and my contention with what the Court of Appeals did in this case is if you're going to do that, then you should also follow, what the statutes tell the full commission to do, which is find it by preponderance of the evidence. I think that you should look at the entire record. And then my argument for elements 1 and 3 of this joint employment test, the implied contract and especially the control, I think the preponderance of the evidence, I would argue the overwhelming evidence shows that my client Truesdale did not control plaintiff in this endeavor. So I think that if the appellate courts are going to sort of assume this role over what normally the Industrial Commission does, then they also should be able to point to and show that they have reviewed the entire record and made their findings, their conclusions on the preponderance of the evidence.
Counsel, I don't want to jump too fast into your positions, but I did want to ask you this hypothetical. I want to change the facts a bit. You have law enforcement doing traffic control, you have a contractor, but instead of a member of the public injuring the law enforcement officer, you have one of the employees, say a truck driver, who falls asleep and runs into the officer, causing significant injuries. I understand your position there would be that upon a showing of that there could be a negligence claim against the contractor, whereas I see many cases where under similar circumstances, the contractor is trying to seek protection under the Workers' Comp Act. Can you help me sort through this?
Right, so just to be clear, the truck driver that hit the police officer would have been employed by Truesdale, my client. So we would be arguing that he was our employee, therefore you can only sue us in the industrial commission. Yeah, no, I don't think that's a proper argument. And again, it would be inconsistent with what I'm going to argue today.
Well, it would be inconsistent.
Yes. No, yes, I think that in that case, plaintiff in this case, had he been hit by one of our employees, I would not call him a co-employee. Yes, I think that he would be able to sue that truck driver in civil court for negligence and whatever, respondent superior vicariously sue the employer. Yes, I would.
Now, am I correct in believing that these relationships can be altered by contract? So, for example, if the contractor in agreeing to hire sheriff's deputies or law enforcement officers, if they wanted to avoid general liability and only be subject to exposure under a workers' compensation recovery, they could put that in an agreement. Am I correct in that?
I think that you can agree as an employer, you can go agree with whoever you want to be your employee and sign that agreement, and they would become your employee. And I would think that would, if you actually went out and agreed that you are my employee, not a subcontractor, an independent contractor, or someone else, then yes, you would hire them, do the paperwork, and then they would be your employee.
But you could also agree with the co-employer that this individual would be a joint employee.
If there was a contract that would meet the first test, which I contend that there was not, that there certainly was an express contract, there's not an implied contract. But yes, if there was a contract, I'm assuming here we would have an express contract, and I think element 1 of the test would be met.
Well, under 9751, it says a reasonable arrangement between such employers for different distributions.
Correct.
So.
That would meet element 1.
Okay, thanks.
So I guess I just want to follow up on what Chief Justice was asking, because I have a similar question, which is I mean, just to get a little bit glib with it, but it sort of seems like in this case, Phoenix Insurance must just be a workers' comp carrier and not have commercial general liability policies, because if it did, this is an odd position to take, the one you're taking here, because it would mean that a construction company in a case like this that fails to exercise reasonable care in protecting against some approximately caused harm to somebody on the work site is suddenly going to be on the hook for a lot of damages in the court system, rather than being able to go to the workers' compensation system and say, we bargained for very settled liability here. So it's surprising to see someone in this situation making the argument, because there's already, the workers' comp is going to be covered by the state, I assume, anyway, right?
The workers' comp is going to be,
I mean, at most, the carrier would be sharing some workers' compensation liability with the state of North Carolina.
Correct. That wasn't the position or the posture when we first talked, but that is correct now that we can only share, and we're arguing that we don't owe anything. I don't represent my employer's general liability. I don't know what they would say about that. I see your point that I could, but from the workers' comp standpoint, and again, to be honest with you, I don't, under the statute, I think you're only supposed to pay a proportion of what monies that you paid part of the salary. So I think that there's probably a very small money value associated with this case, but I do think the principle is important from a workers' comp standpoint, that our workers' compensation policies are written under certain parameters. And yes, while this one may not have had that big of an impact, they certainly could, as to determining who becomes our employees and who doesn't.
What I'm wondering is if maybe the reason that you look at this case and say, I'm surprised that it's playing out the way it is because there's something unique about the facts here that are different than most ordinary circumstances. So with most employees working on a construction site, it's going to be pretty straightforward to figure out, are you an independent contractor or are you an employee? But it seems to me what's so difficult here is that the state of North Carolina is responsible for police power, and it does not give that power to private citizens. And so what's odd about this case is that, there's just, in the normal situation, no one but the state could ever control the details of the work of a law enforcement officer. But you do have this law that's requiring this private company to be supervising this officer. So how do we put that together?
Well, I think that you put it together by just treating this police officer as you would treat any other situation. I think that the uniqueness that you're pointing to actually goes to my argument as to why, I don't think there was an implied contract, but, and how did this relationship come about? Okay, and I have argued implied contracts. I haven't argued no implied contract. I think I've lost on every argument, so I don't know what an implied contract is, but we'll skip to that one and go to control here. Because of the unique relationship, I think that's why Truesdale did not have any control over the plaintiff. Therefore, he could not meet the third element, even if he met the first element, could not meet the third element, and he cannot be an employee of Truesdale because they never actually hired him in the sense that they didn't put a job listing and everybody show up and, okay, we're going to pick you, or evaluate it and say, oh, well, you were a police officer. That put you higher on the list. That's a good quality. We want you. They had to go to either one or two police departments. They never talked to the plaintiff. They didn't talk to any officer other than the two supervising officers. So they went to them and said, bring us these people. They picked the people to come. And then when they got there, they did not train plaintiff to do traffic control work. They couldn't tell him to do traffic control work apart from what the state has already taught him and trained him how to do traffic control work. And then when you look in the record, I mean, the Sheriff's Department they have a policy for this type of stuff. There was a particular argument that Truesdale had the power to terminate any officer that they I don't like you, or you're doing a bad job, you got to go. But I think when you look at the transcript of the officer talking, I think it's clear that the two supervising officers were the ones who had control over who came to the job site, which officers were picked, and they could send them away if they wanted to. I think the testimony was, well, if in fact, hypothetically, Truesdale was upset with one of our officers, we would ask him to go home so as not to jeopardize the project for everybody else. I think that clearly says that Truesdale did not have any termination control over these officers. That was strictly with Captain Overshay or Chief Edwards. The other thing is when you look at the policy, before an officer goes out there, they are asked, or I guess not all the time asked, but they have to have these things approved by the Sheriff's Department. So the Sheriff's Department ultimately has the capacity to hire them and also to terminate them. They can be removed from the project. They can, I think the plaintiff testified that, you know, if I get on the sheriff's bad list, I can be denied these opportunities. If you know, I don't know, don't bring him his lunch on time, he can pull you off of it. So again, I appreciate your point about this is somewhat unique, but I don't see it unique in the grand scheme of things, you know, sort of globally, definition-wise. I think that the uniqueness goes to, yes, you're correct, and Truesdale had no control over plaintiff in the same manner that they would have control over, you know, whether it's their subcontractors, their independent contractors, or other people that they had to bring into this project in order to get the project completed. That was a long answer to your question. I don't know if I hope I answered it, but.
But you don't disagree that the only reason that Mr. Lassiter was working that day was because the supervising officers had looked at the traffic control plan, thought that it had an inadequate number of officers, but instead of their unilaterally adding officers, they had to go to Truesdale to get approval to add additional officers.
I think, again, when you look at the entire record, well, we may have a slight disagreement. I don't know that Mr. Lassiter was, I think that there was either 5 scheduled and a 6th came, or there were 6 and the 7th came. I'm not confident that Mr. Lassiter was the, in fact, 7th one. If he were, then it was because Captain Overshay said, hey, wait a minute, we need 6 people, we don't need 5. Yes, they technically had to call and get approval because they had to change the prearranged traffic control plan. And part of that approval Truesdale did do, but again, Truesdale subcontracted that plan to another company. That company came up with the plan. After that plan was developed, they then went to, you know, had to have the Department of Transportation approve it, had to show it to Truesdale. I'm sure that Truesdale, again, I don't know what the record says. I think it's silent, but, you know, I don't know that Truesdale really put a whole lot of thought into developing the plan other than I've got to get a plan to have traffic controlled in order to meet the requirements of the DOT so that I can repair this bridge. So I appreciate your point, and I do think that evidence would say, you know, you could find a snippet of evidence that said Truesdale approved the change to the traffic plan. But I think in context, I don't really know what approval, I don't think that they were sitting back as, you know, a judge saying yes, no, denied, approved. They were like, yeah, that looks good. Or yes, of course, police officers, you know exactly, you clearly know traffic control more than me. So yes, if you think we need 6, yes, go get the 6th person and put him out there.
So the seminal case that we have is the Leggett case from 1965. In that case, as you well know, it involved the leasing by the contractor of a front-end loader, and in order to do that, they also had to get the employee of the lessor, Mr. Liggett, to operate the front-end loader. Why is the situation here not similar to that? Because in effect, what Truesdale needed to have, they needed to lease law enforcement, lease a badge, and that badge had to come with an operator, which in this case was Mr. Lassiter. What's wrong with that comparison?
I'm going to get the names wrong in the case. In fact, I'm not even going to attempt to call names. But in the Leggett case, as I read it, the court made a point of one of the key facts, if not the key fact, was the evidence in the record that the supervisor for the special employer, not the main employer who owned the front-end loader, but the guy that he loaned, the company that he loaned him to, that supervisor. So the supervisor of the second employer, similarly a supervisor for Truesdale, had specific and direct control over him when he was at the job site. He did not tell him how to necessarily operate the front loader, but he was certainly out there directing him as to, okay, we need you to work over here, we need you to work over here. And I believe that when the accident occurred, that was something that happened, not related to the front loader. I think something else.
It was the front loader. It was just, they didn't require him to do it, but he chose
Right.
to lift
He
the
said,
beam that then apparently
right.
hit the wrong lever, came back in.
He said, I'll help you out, but the
So
supervisor.
why is the directing of traffic officers, you're going to be here, you're going to be here, you're going to be there, based on this plan that was developed by Truesdale, why is that not the same thing as the on-site supervisor in Leggett saying, I need you to take this here, I need you to take that there, even though the injury that occurred did not occur because the on-site supervisor specifically told him to do what led to the injury?
Chief Justice Newby, I would respectfully disagree with your interpretation of the evidence as to the control that Truesdale actually asserted. They did not tell any particular deputy where to go. They were not that specific.
I thought the plan itself indicated where the deputies would be as the traffic control.
I believe that the plan said we're going to do this bridge, therefore we will need traffic officers down on this end. I think 5 or 6 will do. We'll need traffic officers down here. 5 or 6 will do. Captain Overshay, can you handle that? Yes. And so then Captain Overshay went out and picked the particular people, told them where to go. I think even they changed something. He moved plaintiff from one point to another. He wanted to leave, and he moved plaintiff from one point to the other. That movement did not require Truesdale approval. That was, again, I just...
So if the record were to indicate that the plan itself that was Truesdale's plan, approved by DOT, that the plan itself indicated where the officers would be, then would your position change?
Because I still think that is diluted control. Now, I guess you asked me a hypothetical, you hit it in the actual fact. So I don't want to dodge your hypothetical. And so correct me if I'm wrong and tell me to answer the hypothetical. But here, Truesdale didn't, Truesdale subcontracted the actual development of the plan anyway. So they did not come up with it.
But it's their plan.
Correct. But again, I think that when you take that plan and you compare it with what you asked me from the supervisor in Leggett, I do not think it is the same thing. I do not think it comes close to the type of control that is required that made the supervisor in Leggett an employer. It does not exert the same control that Truesdale exhibited here, such that it would make plaintiff an employee. I mean, again, this is where you get into the weighing of the evidence. I mean, we can argue all day long over what that means. We can argue. I can point to other evidence. Again, I would go back to the policies put forward by the Sheriff's Department itself that actually states that when you go do extra duty work, you will work pursuant to the supervision of your officer. It does not say you will go work pursuant to the supervision of another officer.
Does that mean, and that sort of gets to one question I have, which is that, do we need to answer some factual question about what exactly the officer's role on the site is? Because I do think your strongest argument is that certainly at the time that this occurred, if the sheriff had said to just say any deputy, just generally, arrest that man, I just thought that a deputy would have to say yes, sir, and carry out the arrest. If an officer assigned to this duty to assist at the construction site was told by one of the employees of Truesdale, arrest that man, they would probably say no. You don't tell me what to do, buddy. The sheriff does.
That's correct.
But is sort of that law enforcement duty the reason that the officer is there, or are the officers there just to sort of because having them there on the site and the patrol lights are on and they're making sure that that's going to avoid, assist with the construction, avoids any accidents. It's not a law enforcement role so much as, you could have sort of traffic guards doing this that weren't sworn law enforcement officers. And if that's the case, is the fact that the company is saying, here's when we need you to show up and we'll have this plan pursuant to DOT that tells you where, that is the control, enough of the control anyway. I think that might have been what the Court of Appeals was thinking.
And I would say no. And again, I would go back to, I don't know that I can say it any better than my argument is contained in the findings of fact of the full commission as to the weighing and what constitutes control. And I do not think that there was a problem with that. Yes, I think that the Court of Appeals changed it. They saw different facts differently. But I will note that, again, I think all 7 of you should know I have deep respect for the Court of Appeals, and so I don't like to willy-nilly come up here and say they sloughed it off and didn't do their job. But I don't know that they looked at the entire record. Again, the Court of Appeals opinion made no reference whatsoever to the policies from the Sheriff's Department. And I think that that is at a minimum crucial evidence of, should have been considered, because I think it says a lot about who controls this officer when he's out at this job.
I take your argument again. I'll do what I think you're a little reluctant to do, which is say it could have been that the Court of Appeals was so focused on explaining why Wicker made no sense and kind of rejecting it, that when it got to the rest of the sort of critical parts of what needs to come after that, they kind of went through that really quickly and didn't spend the time that the full commission did on.
And I think they found snippets of evidence. And again, obviously Chief Justice Newby has presented a great argument of both a contract and also control. I disagree with it, and I don't think the evidence supports it. But other than complimenting Chief Justice Newby, I forgot what I was going to say. So
you may want to reserve the rest of your time for rebuttal.
Well, you're right. I am at 4 minutes, and I don't want. I love the discussion. I haven't gotten to element 2, which is kind of the basis of my PDR, and I'm not going to concede element 1, but I think that my strongest argument is 3, the control. And again, I would assert that the overwhelming evidence shows that the Sheriff's Department controlled everything that plaintiff did at the site. Truesdale only had minimal control at the very beginning when they came up or approved a plan that someone else came up with that had to be in conformity with what the DOT recommended. And I don't think that's enough control. I'll reserve the rest of my time for rebuttal. Thank you.
Thank you, counsel. We'll hear from Appellee.
Mr. Chief Justice, Associate Justice, may it please the court, Stephen McIntyre here on behalf of Mr. Lassiter. Mr. Lassiter, I just want to point out, is in the courtroom with us. We thank him for his service. It's a miracle that he's still here. The scar on his face is from this accident that we're here about. Let me address Justice Dietz's question about the mixed question of fact and law that the Court of Appeals looks at de novo. I think, and I don't want to say why it is that's been the case for decades of our jurisprudence. I think that is the case because often you're not just in front of the Industrial Commission that's making jurisdictional findings. Oftentimes where we find ourselves as on the plaintiff side is this in front of the Superior Court with a third-party negligence claim where facts are going to be found there potentially in a 12B1 hearing on subject matter jurisdiction, or is the Industrial Commission going to be the one to find the jurisdictional facts as to whether they have jurisdiction? And so when you have these competing, an agency oftentimes looking at the same set of facts as the Superior Court, you have a collateral estoppel potential issue there. And so I think maybe that is why the appellate courts have said, hey, we're going to look at this as a mixed question of fact. Whatever we decide on the jurisdictional basis, we decide as the appellate court whether or not the Industrial Commission or it lies, as you pointed out, is it a third-party claim?
And your point being, the appellate courts are sort of uniquely situated in that competing fight over who has jurisdiction. It all comes to us.
Exactly.
That's actually the best argument. I've wondered about this for about a decade, and that's the best argument I've ever heard.
Thank you, Your Honor. I think about these things. No. And I wasn't expecting you to ask that, but that's my take on it. Now, let me also just say, beyond that, in response to some of what else was said, it is an awkward position that I'm taking as a plaintiff's counsel who does third-party cases Hey, I want to bring a negligence claim a lot of times. The workers' comp remedy, the benefit of the bargain that the amicus has filed on behalf of, the insurance industry and the employers, they get a huge benefit from that. Oftentimes we are stuck with a severe injury where we're limited with, a maximum compensation rate. We're limited. There's no pain and suffering. We're limited to the remedies that we can ask for. And so I am in a weird position because it's almost like we're saying, hey, limit that remedy. But I think what the court has to do is look at the specific facts of every case in front of it. And this is a case of first impression. It is a unique situation. And as you aptly pointed out also, the state of North Carolina and the county cannot contract away law enforcement duties. When Deputy Lassiter is out there, and we talked about this in some of the record, and if he saw somebody drunk, if he saw somebody, driving crazy, he's acting in his law enforcement capacity. Chapter 20 of the general statutes, which I don't do much criminal law, but, has the blue light statute as well as a separate statutory provision which allows and enforces the law when a law enforcement officer is out there. And that brings me to my point about the record. And I brought this up here. And I think, I always look at the four corners of a contract, right? This is a contract between the parties. This is page 500 in the record. It's what Truesdale produced. And the first paragraph there says that Truesdale, what they signed off on, will furnish law enforcement officers. And that is what they agreed to do. And also in that brief document, they said they're going to pay him by the hour. And so I am very concerned here that if the court comes and says Truesdale's not an employer, when we look at the seminal case, Hayes versus Elon College, which is well-settled case law in which the Court of Appeals did in detail at the outset go through as it applied to both potential employers. There's a strong case to be made, and I laid it out, and it's supported by the evidence in the record, that most of those factors, Truesdale was not going to allow him to go out there and just hire other assistants. Truesdale controlled his time. The crux of the Youngblood case, the other cases, are the element of control. And here, most of the time, and if you look at the Hayes versus Elon factors, it is, did you control the time he was out there? Did you control when and what he could do? Now the specifics, was he, did they tell him to wave your wand this way? No. But Truesdale's plan had, they got to turn left. He couldn't just go out there and say, turn right, because the concrete truck's over there. And so when you asked earlier about, if the sheriff said go arrest that man, Truesdale couldn't say go arrest that man. But what Truesdale could have done is said, hey, the concrete truck moved over that way. You got to go over there. And he would have done it. Absolutely, he would have done it, because he was under the control of Truesdale's plan. And when you tell somebody, you got to show up at this hour, we're going to pay you by the hour, we're going to have you here as a part of the plan, and we signed a contract. Nobody made Truesdale sign this. We signed a contract that said we're going to furnish law enforcement officers. They're going to use their blue light. They're going to be measured and paid in the actual hours that they're used. I mean, Truesdale agreed to all that. That's an employee. I mean, look at all the Youngblood, Hayes, all those cases. And so
I assume you will agree with me in the Leggett case, the contractor did not tell Mr. Leggett how to operate. He simply told him where to position and what tasks needed to be completed, which is comparable, as I said earlier, perhaps, to the situation here.
I totally agree with that, Your Honor. And if you look at page 13 of the transcript, which is in the record, what Deputy Lassiter testified to, said, I was working under direction and doing traffic control for Truesdale. I mean, that's what he testified to. That was his understanding of what he was doing. The sheriff didn't tell him, where to go. Now the sheriff's people were out there also, but it was a development in conjunction with them. Let me just say,
I've got a couple of foundational questions.
Sure.
Will this ruling from this court impact ultimately how much workers' comp is received? Because it seemed to me that in reading the statute, all it does is it divides up what percentages are going to be paid.
Mr. Chief Justice, that's exactly the point I was going to make from the plaintiff's perspective here. It does. And the reason I'm arguing this position is because average weekly wage under Chapter 97 is calculated by what the person is making in the job that they're in. And I'll give you an example. I had a client who was working for one county's EMS and on the weekends worked, extra time for another. She happened to hurt her back on the weekend job. She couldn't recover for being out for months based on her salary for her full-time EMS job. It just so happened she was hurt on her part-time job. That's the critical element here from the workers' comp perspective. Thankfully, Deputy Lassiter survived. If what his average weekly wage should reflect is the fact that he was making money not just from his salary as a sheriff's officer, but also from his off-duty employment in his capacity as a sheriff's officer. And that money can be a lot. Now, for right now, I think, what Mr. Jones was saying is, well, it's not really that big of a deal because in this specific situation, we didn't pay him that much. It does matter a lot. And it matters because a lot of times these deputies are working, making more money per hour for off-duty employment. They're still doing their law enforcement job. And if they get hurt and, for instance, say, pass away on that job, if he would have died, his family would have gotten 500 weeks. But we should be able to add the salary from both. And in here, it's not going to be that. It's not going to be that much. But this is for the next man up, right? If they're making a lot of money from this off-duty employment, the average weekly wage, if you find joint employment, those should reflect truly what he's making in his employment as a law enforcement officer. That's why in this case I have argued for joint employment. Yes, it potentially could hurt plaintiffs, candidly, help the insurance industry. That's why it's kind of funny. I think the amicus was looking at it purely from a workers' comp perspective. But what we have to do as attorneys and as the court is look at the specific facts at hand. And that's why in my brief I asked for a very narrow ruling. And I don't think the court has to overturn Wicker, overturn anything. I think it just has to say, look, the nature of the work here is literally exactly what Truesdale signed up for. We're going to furnish law enforcement officers.
So you're talking about for the next one, and
Sure.
I appreciate that. And,
Sure.
And that's what this court does. With our jurisprudence, we try to look ahead and think, okay, overall scheme of things, what's best here. My concern with your argument is the scenario that I gave Mr. Jones about the truck driver for the contractor who negligently plows into the officer. But then we look broader. So I don't know where the greatest exposure to law enforcement officers might be. It could be doing this contracting work, and I understand it benefits everybody to have the blue lights and all these things getting people's attention. It's good for the community. It's good for the safety of drivers. I get that. But I also know law enforcement officers go into private security situations like at hotels or churches or other places like that. And what I'm wrestling with is, well, what happens if the owner of the motel directs the police officer into a situation he knew or should know was terribly dangerous and the police officer gets injured? I mean, is there only the workers' comp recovery and perhaps, given the scenario you've talked about where, it's kind of guaranteed and you just up the average weekly wage based on that payment? Or is it better to say, no, they can sue what could be the joint employer that would not be the joint employer, so the other company?
I think that's a great hypothetical question and one that the plaintiff's side has wrestled with. I will say on a public policy basis, I think that's something the court has to decide. In this specific case, we made no allegation. I don't think there was any allegation that Truesdale did anything negligent. It was actually the driver that we collected all the third-party money we could and don't know if there's a workers' comp lien, who's got the lien, and all that. And so I think that is a fair question. I think what the court would have to do in that circumstance is make a specific factual determination in that situation, what level of control the employer, the special employer had. Did that amount to the Hayes versus Elon College factors? Did that control rise to the level of being a joint employer?
So I understand your position regarding the way in which this court can issue a narrow decision, but it seems to me this is also a case of first impression in the sense that the Court of Appeals said that to prove simultaneous employment by two separate employers, the claimant can rely on two doctrines, the joint employment doctrine or the lent employee doctrine. And as I look at our precedent, it seems pretty sparse, and I'm having a hard time figuring out, are there really two separate doctrines there, or is it just one? If there are two different ones, what's the distinction between them?
I have a hard time with that too, Your Honor. And I think in the co-appellee's brief, exactly what they argued as well. And I think what the case law is, I think it's best spelled out in the Anderson case. That says that joint employment occurs when a single employee under contract with two employers and under the simultaneous control of both simultaneously performs services for both employers, and when the service for each employer is the same as or is closely related to that for the other. In such a case, both employers are liable for workers' compensation. I think that's the test. I mean, that's spelled out in the case law. I think Wicker, as Mr. Horner pointed out in his brief, kind of goes into a lot of dicta and unnecessarily tries to, merge the doctrines and then, look at each of them. And I think that's more confusing for the jurisprudence than, what the Anderson case, clearly spells out. And it is a fact. It's a specific question of fact and law as to each case. And I don't think the court has to do anything more than that in this case.
So you're suggesting that there's essentially one test for joint employment, and whether you call it joint employment or lent employee is essentially the same thing.
That's correct. That's what I think. And I think that going into, was it a special employer? Was it a lent employer? All that stuff. I think that's more confusing for practitioners. I think it's more confusing for the industry that deals with this. I think it's really simple. I mean, we've had Hayes versus Elon College since the 1940s. That's the test, right? The Court of Appeals kind of ran through those factors, to begin with. And if you meet both of those tests and you're serving, both employers at the same time, like the Anderson case points out, we don't need to delve into making it more complicated, than it needs to be. And I think that's what the dicta, and Wicker was really doing was kind of going through an analysis that was candidly unnecessary because, they really resolved the case at the beginning. And that's what I would say in front of this court is that I think when the court holds a holding that is more broad than it needs to be, it makes for, bad precedent and bad law. And so I would ask the court, I see my time I'm going to give to Mr. Horner, I would just ask the court, in this case, and the reason I filed the Form 18 with both employers within 30 days is because I was like, boy, it could, I can see both. And if I leave one of them out, it's going to be a problem, right? And so I kind of feel like from all the evidence and everything and looking at the case law, was he serving both at the same time? That's what the Anderson question says. Was he doing the job for both at the same time? Did they both benefit from it? I think the resounding answer to that is yes. I think for precedent purposes, I think that, we would just, I think the court has to say, hey, look, we just make a narrow specific holding. But the beauty of this, Chief Justice Newby, you pointed out earlier, the parties can contract about this. I don't think they can contract the way he's doing his job as a law enforcement officer. But all the court has to say, and I suggest this in my brief, is say, in the future, guys, when you're doing this, just say, hey, Truesdale, you're going to, pay for, 10% or 50% or, whatever. That's the bargain, right? And thankfully, the legislature spelled that out when they, crafted the statute. And so, I think the jurisdictional question here is, was he under the control of both? Was he being told the hours he could do, paid by the hour, when he could do it, where to be? If he's under the control of both, I mean, that's the case in front of you. That meets with the Anderson precedent. And the narrow holding is there, and it would encourage and provide stability if the court's like, guys, the statute says contract about it. They just didn't do it here. And I'll give the balance.
I have one quick question. I think it's probably better to ask you than your friend.
Sure.
So just to make sure I understand. So from the perspective of a construction site, you have a situation like this, you have a public employee working the construction site. So in my understanding, because sort of the light bulb went on for me on what's going on here. So from the perspective of Truesdale here, the average weekly wage would be calculated just based on the formula that we've laid out in the case law based on what he was earning doing that work. But you're saying from the perspective of the sheriff's office and I guess the county, who's the other sort of employer here, you would also consider the wages from the sheriff's office
Absolutely.
averaging it. So you don't just say, well, in this job, which is not your triple sheriff's job, you're like time and a half, so it's just that wage.
That's correct. And the nightmare scenario here, and why it's so important that he be recognized as a law enforcement officer, if he went out of work, I mean, he'd be looking at probably the minimum comp rate. Now I would argue it should be higher than that, but that's not his full-time job. If that was the finding, and he's not recognized as being that, he's out of work. Guess
right,
what?
I see now.
He gets like nothing.
The Tedder case, which is say because that's also a temporary employment, so you'd find yourself not getting workers' comp as you would if it was your full-time job as a sheriff and you're injured. It's just till the project's over on the
exactly. To be clear, everybody's conceded he's an employee of the sheriff's department here. That's not even before the court. But what I think would be fair in this situation is, if the court finds, hey, Truesdale's paying the guy, controlling the guy, he's actually increasing his wage earning capacity, the workers' compensation award should reflect his true actual wages from both jobs because he's under the joint service of both. And from the plaintiff's perspective, that is actually, that's equitable and it's fair and it meets within the statute. And that's why I would say he's going to get punished, for his average weekly wage if it's just one or the other. And so that's why, we would say it's both. In this situation where there's no negligence on behalf of Truesdale doesn't just get to walk away and say, man, we made all this money, we furnished the law enforcement officers, like, good luck, county, pay everything. And that's what they're arguing. I think that's what Ms. Horner's going to argue right now. Thank you.
Good morning, Chief Justice Newby and Associate Justices. My name is Greg Horner. May it please the court. I represent the Sheriff of Robeson County, the Appellee, and I was hoping to address very briefly before I proceed the questions of Chief Justice Newby and of Justice Dietz. The first question being, would one result or the other change the amount? And I want to take that and refer back to sort of the rule of liberal construction in workers' compensation cases. This is the rule, probably the most oft-cited rule in workers' compensation, that interpretations of the law should be given to benefit the injured worker to the extent that that's possible. This sort of narrow, pinched interpretation that's being sought by the other defendant to say that the two types of work have to align exactly and so on and so forth, I think is incorrect, and here's why. Under the rule of liberal construction, my client is a self-insured sheriff. They pay their own bills. There's actually not insurance for this law. It comes out of the budget of the county of Robeson. That's important. And the problem with the rule being proposed by the appellant is if you apply that rule, if you construe this portion of law, 9751, very narrowly, what happens if the primary employer is uninsured or insolvent? If Robeson County can't pay the judgment, if Robeson County can't pay the claim, who does the plaintiff turn to? I don't think that's liberal construction. I think that's leaving a plaintiff out in the cold with no claim. The other side of this is, Justice Newby, you mentioned in Leggett, the control that the contractor had. There was a lot of testimony in that case about how he had significant control over what that end loader driver would do. Go move that stump, go move that dirt, so on and so forth. He had him pouring concrete at one point, I believe. But to your point, he didn't tell the end loader operator how to operate that piece of machinery. And this goes to the element of control. Of course, the sheriff had an element, in fact, a significant element of control over how these officers operated on that site. That is a fact. But so did Truesdale.
So I want to go to your first point about liberal construction. Are you suggesting that we apply a more relaxed standard for determining control in workers' comp cases than we would in other contexts, like respondeat superior, like where there's a claim of respondeat superior?
I don't think so, Your Honor. I think there's cases where it's been said that total control or equivalent control isn't necessary to find joint employment. The cases have said there has to be some control. And and I think that's the difficulty for the court, is deciding how much control. But in this case, you had Truesdale, who was in charge of the entire project. You had Truesdale, who had to say, this is where you have to be. Is it exit 33? Is it exit 29 down in Robeson County? And Truesdale controlled that. Now, the officers could decide amongst themselves, and there's record evidence to this effect, where to go. But the exits and the traffic diversions and the closures were decided by Truesdale's needs, and therefore the necessity of the officers were also decided on that basis.
So one thing I'm struggling with respect to that argument is, you can imagine all kinds of situations where there's an independent contractor and the party contracting with the independent contractor tells the independent contractor where its people have to be by virtue of the work assigned. So for example, a landscaping contract, well, you're going to mow over here. I mean, by doing that, you are determining where the independent contractor's employees will be. How is that different from here? I mean, of course they needed deputies at that particular exit because that's where the work was being done.
Correct. And I think Justice Allen, Mr. McIntyre addressed that, which was essentially Truesdale could change their decision at any moment. They could say, we need to shift a half a mile down the road. And again, they're telling that person where to go and where to work and what to do. So they don't control the details of the work that the sheriff's deputy would perform. In other words, whether to flash the lights, whether to use the flashlight, how to control the traffic itself, but they are telling them where to go and where it has to be. And that's a lot like the Leggett decision, this court's decision in 1965, where you had a general contractor and this end loader operator. And what the general contractor said was, I told him what he had to do with that machine, but I had no control over how he operated that machine. And I think the reality here simply is not a general contractor situation. As pointed out, the Hayes factors are largely met. But this contractor, Truesdale, also came in and hired these people. This contractor made them use their timesheets. He paid them by the hour, as mentioned under Hayes. And while there were some Hayes factors that went the other way, for the most part, they did fall on behalf of Truesdale in addition to the county, or I should say the sheriff.
So what do we do with, one thing that troubles me about this case is, while I think the Court of Appeals had some sound or made some sound criticisms of Wicker, it also acknowledged the existence of Wicker and pretty much expressly said, we're not going to follow it. And of course that runs contrary to our jurisprudence in res civil penalty that says the Court of Appeals is bound by its own precedents. How do we deal with that issue?
I think the biggest piece there, Justice Allen, is that there was a contract which controlled the outcome in Wicker. So number one, the hospital had contracted with Compass Group, or I think it was called Crothall Services, a sub of Compass Group. And in their contract, it said, these employees belong to Crothall Services. So the initial analysis under the Collins case is there a contract? And right from the start, there was no contract found in the Wicker case because of that controlling language. And so the Wicker case should have stopped with that. There was no need for them to proceed into that secondary analysis on the secondary problem.
So you're saying that the Court of Appeals decided not to follow what was dicta in Wicker.
That's exactly what I'm saying, Your Honor.
But would you agree with me that when you read the COA's opinion, it doesn't say that?
Not explicitly, no.
It reads like, Wicker really is on point, but we're just not going to follow it.
I would differ with that as well, Justice Allen. When you look at the Leggett case, which really, as Justice Newby described it, is our seminal case, what they found was if you'll excuse me, I want to make sure I get this quote just right. But on that second element on, sort of the nature of the work, are they doing the work of the special employer? Specifically, what they said was this: we think the work being done at the time of Leggett's death was beneficial to both McCotter and Crowder. And I think that's very clearly the case here. Joint employment, because yes, there is an element of benefit to Robeson County, but at the end of the day, Truesdale is the one that with the true benefit here. This man was working, yes, under a certain amount of control from the sheriff, but the real benefit here in order to the construction company. I mean, this is a project that covered 2 counties, Cumberland and Robeson, covered several years' time. This is a very large contract. So Truesdale comes in, they're able to hire my sheriff's officers, and at the end of the day, they wash their hands of it and say, we're not liable. We don't think that's the right outcome. We think there are very serious policy implications along these lines, Your Honor. And a couple of them are these. Amicus has said, the sheriff can just forbid the officers from moonlighting. And that's very easy for Amicus to say from behind a desk, frankly. But these law enforcement officers, not only in Robeson County, but statewide, depend on these moonlighting jobs for their income. And I won't go into the average weekly wage analysis, but the fact is many of these officers moonlight across a huge number of industries, whether it be nightclubs, restaurants, grocery stores, and the like. The natural reaction of sheriffs to a ruling, if it goes the direction of the appellants, is going to be to want to shut down moonlighting amongst their officers. And if that happens, as mentioned by Amicus, what happens to those officers? What happens to Robeson County, for instance? Do they lose officers to richer jurisdictions like Mecklenburg, like Wake? Because they can't pay as much at the base pay, these officers may need their moonlighting income at a higher level. The same is, this is also a serious consideration. What if the entire state loses officers to jurisdiction where moonlighting is encouraged? And that ultimately is one of the sheriff's biggest concerns here is he wants his officers to be able to be taken care of. But at the end of the day, he doesn't set that budget.
But if we rule for plaintiff, might that not discourage private employers from hiring officers?
I think in this case, no, Your Honor, because in this case, they were mandated to hire the officers.
Well, I understand, but looking beyond this case, because in most instances, it's not there's no statutory requirement that, requires private companies to hire officers.
I don't know if employers will look that far down the road, Your Honor, but what I do know is if they need a law enforcement officer, they're going to be inclined to hire one.
And they can contract for the scope of that employment.
And Your Honor, Justice Riggs, that is the issue. In every one of these cases, this issue can be decided by private contract under 9751. So I see my time is about up. So in conclusion, we believe the Court of Appeals got it right. We think that was a well-reasoned decision, and we would ask this court to uphold the appellate court's holding in Lassiter. If there are any questions, happy to take.
Thank you, counsel. Rebuttal.
Thank you again, Your Honors.
Before you get started, I hate taking people's rebuttals, so I'll be real quick. But the workers' comp makes my brain hurt sometimes, so I'm hoping you can help me figure something out. So I feel like a light bulb went on when I heard your friend's argument, and then it went off again as I started thinking about it. So help me get the light bulb come back on. If I thought the rule for temporary employment to calculate average weekly wage would be that you do the calculations, you get to the 2/3 and so on and so forth. Then you look at how long the temporary employment would have lasted, and you also multiply by that fraction. So if it was temporary employment for just 1 month out of the year, the average weekly wage is 1/12. You'll multiply by 1/12 then as well to calculate the average weekly wage. Am I wrong about that? Has that case law been overturned?
I think most of the case law about co-employment, the co-employment is not counted at all. I think in this case, the joint employers, the co-employment, again, I did not expect this to be an average weekly wage case. I don't know that I understand entirely this court's last average weekly wage case, and I'm not entirely sure I understand Tedder. But so I think there are different ways to calculate with different arguments to calculate it. But I think that you would take his 255 or whatever he made, divide it by 52, add that into what he's currently making as the sheriff's department, and then each side would pay a proportion to what they paid in salary for him. It's a little bit different than other temporary employment.
Okay.
Real quick, the controlling the time, just a factual point. The Truesdale did not control his time. I think Justice Allen might have been getting to this in a sense, but we're going to do bridge work this day from this hour to this hour. That's when we need you here. Period. That's all they controlled. Captain Obershea picked the officers, but he was in complete control whether they worked 2 hours, 8 hours. Again, I'll go back to the policy again that the Court of Appeals ignored. That sets that they can't work but a certain amount of time. So I disagree with that fact. And again, I think the overwhelming evidence says that's not correct. Real quick, the big policy argument that I'm going to make is I'm not going to make a policy argument except for from an insurance standpoint, which I put in my brief and the amicus said. But when you're going back to why did the Court of Appeals do what they did, I do think that they attempted to carve out an exception for off-duty police officers. The policy standpoint is there is no policy. You should not be carving out an exception for police officers. In this case, I think you will create more problems than you fix trying to figure that out. I think that is for the legislature to do, and the legislature has done that in workers' comp. It's completely different, but they recognize that volunteer firemen are different. They're not like other people. They carved out an exception for volunteer firemen. Therefore, you should treat police officers the same way you treat joint employment officers. Justice Earls,
Thank you, counsel.
Don't have more
Your
than
time's
that.
expired.
Thank you.